Hello, David.
Hi, Irina. Looking forward to this second session.
It's going to be very interesting. As always, the Better Living Group is about providing a service that we can to all the people in the group, and that is allowing us to learn whatever it is we need to know. And sometimes it's hard to find out what it is we need to know. So we made this flip book called Going, Going, Gone. And we've also made a different flip book called Having Your Way with Your Will. So this is all very interesting because to the way I see things, if we're not aware that there are things available, we don't think about them. So I'm going to explain to you why we developed the power of attorney in our section of the book Going, Going, Gone. It's really important that we understand what the power of attorney does. So I'm going to give it over to you because you have a far greater understanding and you have a far better way of talking about it. So David, over to you.
Okay, thanks, Irina. I'm just going to bring up, whoops, I made a mistake there. I'm just going to bring up our Going, Going, Gone book as a shared screen. And hopefully now you can see the front cover of our book.
Yes, I can. Thanks, David.
So that's the way the book works as a flip book. It's like turning the pages on a real book. Last session, we actually went through the Going, Going, Gone introduction, and I gave a little session on what is contained in the book and how you can access the links and what have you. Today, we want to do the power of attorneys, and this is the second going. This is the going while you're alive. And it's important to have this power of attorney, a POA, if for some reason you lose the ability to control certain aspects of your life. A power of attorney may be an appropriate vehicle to allow your intentions and wishes to be carried out. For example, if you've got an acquired brain injury through a car accident or something, you develop dementia, you lose the power of speech for whatever reason. You may have had a stroke, and that would apply also to being able to sign documents if you lose the ability to move your hands or limbs properly. And a power of attorney is defined as a legal document allowing individuals to appoint someone who can make decisions about financial and personal matters when you are no longer able to do so for yourself. Now, there's three basic types of powers of attorney. There's a general non-enduring power of attorney. There's a supportive power of attorney, which is only help with decision making. It may be that that person can speak for you or help you to look at documents and that type of thing. And then there's a general enduring power of attorney, which covers things like financial, legal, and personal decisions. And they can be very important, as we said at the start there, if you lose the ability to be able to make decisions for yourself or physically communicate them to other people. So each of these powers of attorney is different. Non-enduring and supportive powers of attorney continue until either revoked, which is cancelled, or you lose capacity to make decisions on your own. And at that stage, you should be thinking about whether you need, or before that stage, whether you need an enduring power of attorney, which continues after you have lost your capacity to make those decisions on your own. Now, you can get much more information about these powers of attorney from the Office of the Public Advocate website. We're purposely keeping this book short because we don't want to provide too much information to be taken in at the one time. If you click on the links that are contained in the book, you will actually be taken to the relevant areas that will give you some help. Now, specifically for that, if we want to go and have a look at what's contained in the Office of the Public Advocate, and this is a Victorian site. If we click on the link, you should now be able to see the webpage of the Office of the Public Advocate. Can you see that, Irina?
Yep, I can.
Good. Okay, so you can see this is a fairly extensive webpage, and it goes through in more detail what is an enduring power of attorney, what happens if you don't make an enduring power of attorney, how to choose a lawyer or an attorney or a solicitor, what happens when you appoint more than one attorney, because that is an option. You might need someone to be a backup in case the person who is your attorney, for whatever reason, becomes incapacitated or killed, maybe in a car accident or something. That other person is your backup. How to complete the forms, which form to use, the risks and safeguards involved in powers of attorney, the witnessing requirements, ending and cancelling a power of attorney. You might want to change who your power of attorney is or who your attorney is. And then there are forms and other resources down at the bottom of all this. So I'm not about to go through all of this now because it will take a long time to do so. What I would like to do is to show you some of what is involved with this. Now, I think probably the easiest way to do this is to go straight to the basic forms. Now, talking about the basic forms, there's a short form available and a long form available to you. The short form is basically if you only have one or two alternative attorneys. And in that form, you need to specify what decisions your attorney can make. So I'm going to show you that form in a minute. The long form is only when you have more than two attorneys appointed. And I don't know whether most people would want more than two, but that's a personal decision. So what I'm going to do now is click on the link to the short form. And it's asking me to download it. Wouldn't you know it? All right, I'll save it and then I will actually open it. Now, Irina, can you see enduring power of attorney appointment form?
Yep,
here?
I can.
Okay, so it gives you a lot of explanation about what the form is. And then as you get down to the bottom of this document, it actually comes up with the form for you to fill in. So you can see I can now, if I wanted to, fill in my name, even if I miscapitalise it. And then, so you can see I'm filling that all in. If you've had a previous power of attorney, you can then revoke it on this form. And here is where you actually nominate who is going to be your attorney. So it's all fully explanatory. You can see up the top, it says this form allows you to appoint an attorney and up to two alternative attorneys. You also need to specify what decisions your attorney can make. If you appoint more attorneys or more alternative attorneys, use the long version of the form. So there we are. So you name the person, you put down their address, and then you go here and you have to tick the box or fill out the details. So you can authorise my attorney to do anything on my behalf that I can lawfully do by an attorney, including both personal and financial matters. Okay, so you can tick the box. And if you don't tick the box, you don't go any further. Or you can authorise my attorney to do anything on my health that on my behalf that I can do lawfully by an attorney for personal matters only, financial matters only, or for this following specified matters where you specify, by, I'm not typing too well today. Doesn't matter, you know what I mean. Specify matters, I-N-D-I-V-I-D-U-A, individually. So you can switch all of those on or off at will. And after you've done that, and you'll need to have a serious think about whether you want to have specific matters. Now, I don't know what that might be. specific matter might be to, I don't know, to put your pet in accommodation if you're in hospital or something. It might be something like that, but it's more to do with the longer term arrangements. Generally speaking, I think most people would go for the sort of the general one. I authorise my attorney to do anything on my behalf that I can lawfully do. But there may be some concerns you have if you were to do that. There might be some things that you don't want influenced or changed or specified on your behalf. So that's fine for you to change that. All of these forms are fully changeable. You can download it as I just did and work on it offline. It doesn't have to be done now. You can download it for use at a later date when you've had a chance to think about it, but you'll have it sitting there on file. So you name your attorneys. You just have a look at the other box, tick the box. Do you want to appoint another attorney? If you want more than the one, so click that and then go to the top of the next column, or yes, then you go to the next one, and then you go through. And when you do those, you know, section 3 is how must the Alternative Attorneys Act. You can specify what it is. Like if you want the two attorneys to be able to work together, then any decisions they make must be fully agreed by all of the attorneys. Or severally, you can allow each alternative attorney to make decisions separately, or jointly and severally, where you enable them to do that. And then if you know what you want the attorneys to act differently for you in regard to whatever matters it may be, you can specify what each attorney can do on your behalf in this box here. So, and then you set the start date, when you want this attorney, power of attorney to actually come into force, which, you know, come in at the same time for all matters. You can make it immediately, which is from today or as soon as it's signed and witnessed. Or the other alternative is it doesn't come into force until such time as you lose the ability to make decisions for yourself. Now, that might be a little bit difficult to determine, because if you're starting to lose the capacity to make decisions, how is it determined that you're now in that state? So that may require a doctor to certify, or someone else, someone that knows you well, to say, look, we don't believe that your mental capacity is what it could be, or you physically can't speak or sign documents or whatever that might be. And the other alternative is that you can make attorneys have the capacity to act in these matters at different times or for different reasons, which is all specified on the form. Again, I'm cutting this very short because you can look at all of this in your leisure. Now, section 5 of your power of attorney form is conditions and instructions, which is an optional section. You can make certain conditions or instructions that you specify when making the decisions for you. You don't have to place conditions or give instructions unless you want to. And so this is all subject to the conditions and what have you. So conflict transactions, I'm reading this, I haven't read this before. So sometimes there might be a conflict of duty between your attorney to you and an interest of their own, or a relative, or a business associate, or close friends. You can authorise for your attorney to enter into transactions, even if there is a conflict of interest. And in this situation, it may be that a family feud arises at some stage about what they think your best interests are. So in that instance, you authorise the attorney or attorneys to do certain things on your behalf. Again, you have to have a think about this. And also in here, there's a section on gifts. And this is the section, if your attorney has been appointed for financial matters. Now, bear in mind, you also should have a will. And these areas here slightly overlap. However, the thing is, with a will, it comes into force when you are no longer alive. So it may be that in this section of your power of attorney, you want to specify how you want your assets or possessions or interests to be looked after by your attorney. And sometimes it's better to actually dispose of assets before you die, before it gets into the will situation. And you no doubt will have a think about that. We will be doing sections on will, and we'll probably expand on that at a later date. And then you can also fill in here if you've got dependents, what needs to be done, whether your attorney can be paid for doing what they have to do. And it may just be to cover costs incurred when they're actually lodging documents or carrying out the functions that they have to do. That's not always, well, I don't think it's used very often to pay your attorney to do things. It's usually a family member or a close friend who do it for you anyway. And then, of course, there's all these other optional conditions and instructions you can put in. So you can see it's pretty extensive, this document, and this comes from the Office of the Public Attorney. So you can see it's not biased towards any organisation. It's a government-backed thing from the state of Victoria. Now, Section 6 is you are the principal. You're the person making the power of attorney. You have to sign it. And at this stage, you'll probably run a hard copy of what you filled in online, if that's the way you want to do it. So you put your name there, you sign and date it, but you've got to have 2 witnesses, I think, 2 witnesses, authorised witnesses. And it needs to, when this is signed, it needs to be signed by, one of them has to be a medical practitioner or a person authorised to witness affidavits, and then the other person has to be a witness. And in the previous stuff I showed you, it also tells you what the requirements for witnessing are. You know, it may be in some instances that a person who's going to benefit from your assets and what have you should maybe not be a witness to the agreement, because there is maybe a conflict of interest there, but you can waive that, as you saw previously. Once you've done that and had the witnesses there, you then need to get your attorneys to accept that appointment. You just can't tell someone to be your attorney. They have to agree to do it, which means that when you're doing that, you're making them aware of any special conditions and whatever that you may have and that you want acted upon, or any wishes that you wish carried out. And so that is how this happens. They know that they're going to do it. And here's the one for your alternative attorney. And that's where they fill the things in. Those also have to be witnessed, but in this instance, they don't have to be done by a medical practitioner. So, so this section here is only if you already have the inability to sign. You can see here, you signed it, someone signs it on your behalf at the direction of the principal. And that basically that's the end of the form. So you can see there's a fair bit in it. There's a lot of instruction given to you the way through. And if there's not sufficient instruction there, you can actually go back to the area here at the Office of the Public Advocate and download documents. See, one of the ones here is witnessing requirements, and we'll just quickly have a look at that because that's something that comes up very often. So in witnessing requirements, 2 adult witnesses are required for an enduring power of attorney. 1 must be authorised to witness affidavits or be a medical practitioner, because they're basically saying that you're in sound mind to actually sign the power of attorney. The following people cannot be a witness: a relative of the person making the appointment, a person who is being appointed, an attorney or an alternative attorney or their relative, a care worker or accommodation provider for the person making the appointment. And you can see here, there's a little video that's available to show you how to do that. So there's a lot of information here. And I think at this stage, we'll actually stop looking at this for the time being and return to the Going, Gone book. So, I mean, can you now see the book with the orange
Yes,
heading?
I can see the book.
Good. Okay, because I'm not sure with the share screen whether it's at times we have to share it to another area, but that's okay. So the other thing is there's an explanatory booklet that's available from, again, the Public Advocate, and it gives a summary of all things, and that's shown here in this live link I've got here. The document is called Take Control. It's an information booklet about powers of attorney, which can be downloaded from here. Now, I'm just going to click that link, and it's asked me to download it again, but I will now open it. And this is what it looks like. It's a booklet of 48 pages, but you won't have to read all of it. However, it's got all of the important things that you need to have a look at. And it tells you about planning about doing your power of attorney, thinking about what your decision-making capacity is. And then it goes on to other things like medical treatment decision-maker, advanced care directive, and we've already done enduring powers of attorney. And so then it's got other information. It repeats a lot of the stuff that I've already shown you, like witnesses and that sort of thing. But this is the overall document. So I'm going to stop sharing screen now. Hopefully, stop share. And we're back to where we were at the Better Living Group sign and behind there. Do you want to add anything at this stage, Irina?
Pardon?
Would you like to add anything at this stage?
Well, I've been listening to you, and I really think it'd be a great idea if we actually downloaded that Take Control booklet and put it into our next newsletter.
Yes, we'll put a link to it there.
Yeah, because I think there's so much to know in this, and it is not very easy to let everybody know the extent of it, because sometimes it just becomes too hard. And I think this is such an important issue. Powers of attorney, more than anything, I think are really important, so that you actually will have what you want done, not what someone interprets that you want to have done.
Yep.
So, yeah. Thanks, David. You've done a brilliant job.
In session 3, we're going to be having a look at advanced care directives, which is if you have a sudden illness or an ongoing illness that's going to get worse over time. And we'll also look at appointing a medical decision maker for you too, someone that can say that your wishes were that if you're on life support and it looks like you're going to be brain dead and a vegetable, that you can tell them to switch the machine off. Yeah. Or it may be that this person can make certain other decisions for you. Things like donating organs and what have you are usually covered in your license, but I believe there is power for relatives maybe to override that. I'm not sure about that. That's something else we might need to look into before that session. But I think that's basically it. We're looking forward to session 3, which will be that one. And session 4, we'll have a more detailed look at wills.
Great. David, you've done a great job. Thank you.
No worries.